Justice is an ancient idea forged in stone and blood. Long before modern courts, civilizations created 22 foundational laws that redefined what it means to be fair and loyal. You will discover the surprising origins of principles that still govern our lives today. We will see how a king's demand for order could lead to brutal punishments, and why some societies chose compensation over revenge. This journey reveals the timeless human struggle to balance power with compassion. What does our modern sense of justice owe to these ancient rules? The sun-baked bricks of Ur rose from the Mesopotamian plains, a city of ziggurats reaching for the heavens and markets humming with life. Here, around 2,100 years before the Common Era, a Sumerian king named Ur-Nammu did something that would echo for millennia. He carved his decisions into stone, creating one of humanity's first known sets of written laws, a system that predates the famous Code of Hammurabi by centuries. This was not merely a list of commands, it was a revolutionary blueprint for order. At its heart was a profound shift in thinking, moving justice away from raw vengeance and toward a more calculated form of fairness. Instead of a life for a life, the code championed restitution. The principle of an eye for an eye was present, but it was interpreted through the weight of silver, not the spilling of blood. Historian Samuel Noah Kramer pointed out the surprisingly progressive nature of this approach for its time. The code meticulously detailed specific fines for harm caused. It stated clearly, if a man knocks out the eye of another man, he shall weigh out half a mina of silver. This was a calibrated justice, where the punishment was meant to compensate the victim, rather than merely inflict equivalent pain on the offender. The laws covered everything from bodily injuries and theft to false accusations, establishing a precedent that rules should be known to all, written down for everyone to see. This raises a compelling question for our own time. How does this ancient concept of monetary restitution compare to the compensation we seek in modern civil courts for injuries or damages? The idea that a wrong can be righted by a payment, a tangible restoration to the victim, finds its roots in the dusty plains of Sumer. With this foundation of written, compensatory law established by Ur-Nammu, the stage was set for another ruler to refine and expand this revolutionary idea, building an even more famous legal monument. Meanwhile, to the north, the city-state of Eshnauna thrived as a bustling hub of commerce, its own legal wisdom carefully inscribed on damp clay tablets around 1,930 years before the Common Era. These laws of Eshnauna were not just about crime and punishment, they were a comprehensive blueprint for a stable society, reaching into the very marketplace to ensure fairness for all its citizens. The code established fixed prices for essential goods like barley, oil, and wool, and set standard rates for services from a barber's shave to the rental of a wagon and oxen. This was a profound attempt to use the law as a tool for economic justice, preventing exploitation and fostering a vital sense of trust in everyday dealings. Imagine a farmer knowing exactly what he would pay to transport his grain, or a laborer being confident he was not being overcharged for bread. This predictability built loyalty not just to a ruler but to the communal system itself. Beyond the marketplace, the laws addressed theft, assault, and property disputes with a similar focus on standardized payments. The principle was clear: a broken bone, a stolen item, each had a defined value in silver, creating a consistent and predictable system of justice. Legal scholar Reuven Yaron highlighted how these laws helped standardize legal procedures across the region, creating a shared understanding of right and wrong. The code also reveals a complex and at times surprisingly nuanced approach to social hierarchy. Its provisions on slavery and debt show an attempt to balance power, offering some protections for the vulnerable, such as limiting the terms of debt servitude. This intricate web of regulations, governing everything from commerce to class, demonstrates a sophisticated early vision of a just society. When we hear debates today about government price controls on essential items or rent caps to protect tenants, we are witnessing the same ancient struggle that preoccupied Ur-Nammu, the quest to use law as a shield against economic injustice. This meticulous framework of standardized prices and payments would soon be adopted and dramatically expanded by a neighboring empire, whose famous code would take these ideas to a new and far more severe extreme. 2 centuries after Ur-Nammu, in the Sumerian city of Isin around 1870 years before the Common Era, a new king sought to cement his legacy not just with power but with proclaimed righteousness. King Lipit-Ishtar's legal code opens with a powerful declaration, a divine mandate to establish true equity in the land. He proclaimed his mission was to cause righteousness to shine forth, to bribe enmity and violence, and to bring well-being to the people. This was more than a legal text. It was a statement of ideological intent, framing justice as a form of social loyalty owed by the ruler to the ruled. The code's focus was intensely personal, delving into the very heart of the family and its wealth. It sought to instill loyalty to both familial and state structures by protecting those most often left powerless. Historian Martha T. Roth has highlighted the code's surprisingly progressive provisions for women's property rights, a radical concept for its time. One statute granted daughters inheritance rights equal to those of sons if the father had not formally declared a specific heir, directly challenging the rigid patriarchal norms of the ancient world. Imagine a family in turmoil after the death of its patriarch. Under older customs, a widow and her daughters could be cast aside, their loyalty to the family lineage counting for nothing. But under Lipit-Ishtar's code, that widow was protected from disinheritance, her security guaranteed by the state. This ensured that her continued loyalty to her husband's household was rewarded with tangible safety, binding the family unit together through law. It prompts us to reflect, in what ways do our own modern inheritance laws continue to evolve in the pursuit of gender equality and fairness? The struggle to balance tradition with progressive rights within families is as old as civilization itself. These early steps toward social justice, etched in clay for the people of Isin, established a powerful precedent that the law could be a shield for the vulnerable, a concept that would soon be tested and transformed on a grander and far more ruthless scale. Rising from the heart of Babylon on a gleaming black stone stele, the image was meant to be indelible. Carved at its summit around 1754 years before the Common Era, King Hammurabi stands before the sun god Shamash, the deity of justice, who hands him the sacred rod and ring, symbols of divine authority to rule. This powerful visual proclaimed a revolutionary truth, that the king's laws were not merely his own, but the will of the gods themselves. The Code of Hammurabi was a monumental leap in legal history, a collection of 282 statutes designed to unify a vast and diverse empire under a single, standardized system of justice. Its most famous principle, lex talionis, echoes down to us today: an eye for an eye, a tooth for a tooth. The code states with chilling clarity, if a man puts out the eye of another man, his eye shall be put out. This was not mere brutality, it was a calculated attempt to limit vengeance, to prevent a minor injury from spiraling into a bloody feud. Yet this harsh symmetry was only one part of a far more intricate legal machine. The code demanded absolute loyalty to the state and its judicial processes, imposing the death penalty for perjury and false accusations, seeing such lies as a direct attack on the very integrity of the court. This intricate framework extended into every corner of life, from commerce and property to family and slavery. But its promise of standardized justice came with a crucial caveat: the law was not blind to social class. Penalties varied dramatically depending on whether the victim was a noble, a commoner, or a slave. A noble who injured a commoner might pay a fine of silver, but if a commoner dared to strike a noble, the punishment could be 60 lashes with an ox-hide whip. This was justice calibrated by hierarchy, reinforcing a rigid social order where duty and consequence were defined by one station. Consider the code's stark approach to professional accountability. If a builder constructed a house so poorly that it collapsed and killed the owner, then that builder would be put to death. This law enforced a brutal but direct form of responsibility, creating a powerful incentive for quality and care. It makes you wonder, how do our modern liability laws and professional malpractice insurance compare to this ancient, visceral form of accountability? Hammurabi's detailed legal framework, with its blend of divine mandate and meticulous regulation, set a precedent that would influence legal thought for millennia. Yet, while Babylon was refining its laws of stone, another civilization on the banks of the Nile was forging a concept of justice based on a far more delicate and enduring principle: the weight of a feather. Far to the north, in the rugged highlands of Anatolia, the Hittite Empire forged its own distinct path to justice. From around 1650 to 1100 years before the Common Era, this powerful kingdom of charioteers and fortress builders compiled a legal code that defies simple categorization. The Hittite laws present a fascinating duality, where brutal penalties for certain crimes existed alongside a remarkable and pragmatic leniency for others. This was not a system solely built on fear, but one that cleverly used compensation to build loyalty and maintain social order. Scholar Harry A. Hoffner noted the Hittites were remarkably practical, often revising their laws to reduce punishments and substitute fines for mutilation or death. This adaptability reveals a living legal system, one that evolved to meet the needs of its people. Many offenses we might expect to be capital crimes, such as assault or even certain forms of homicide, could be settled through carefully calibrated payments. Theft, for instance, was typically resolved by requiring the thief to repay many times the value of what was stolen, a powerful economic deterrent that kept the perpetrator alive and productive. In cases of marital disputes, the laws specified financial settlements for divorce, protecting the economic standing of both parties. One statute illustrates this focus on resolution over retribution with stark clarity. It states that if a person kills a merchant, the punishment is not execution. Instead, the perpetrator must pay compensation to the merchant's family and cover the full cost of the funeral rites. This law prioritized the restoration of the victim's family and the cleansing of the social stain caused by the death, all while preserving the life of the offender as a productive member of the empire. This pragmatic approach fostered a powerful sense of loyalty to a king whose justice could be severe, but was also often surprisingly merciful. How does this ancient concept of resolving harm through compensation and restoration, rather than pure punishment, resonate with modern criminal justice reforms that emphasize victim-offender mediation and rehabilitation over long prison sentences? The Hittite legal tradition, with its unique blend of the severe and the compassionate, stands as a testament to the ancient world's complex and varied search for a justice that could both command fear and earn loyalty. While the Hittites were refining a system of compensation, a very different legal philosophy was hardening in the north. The Middle Assyrian laws, etched onto clay tablets around 1076 years before the Common Era, reflect the soul of a warrior empire. This was not a code designed for mediation, but for absolute control, enforcing a rigid social order where a woman's body and conduct were treated as property to be fiercely regulated. Legal historian G.R. Driver described these laws as exceptionally severe, a system where the protection of family honor and patriarchal authority justified extreme brutality. The statutes focus relentlessly on women, prescribing their behavior down to the most intimate details. One law grants a husband the right to brutally disfigure his wife for leaving their house without his permission, a punishment meant to physically brand her disobedience for all to see. The control extended even further into the realm of reproduction. The laws prescribed death for a woman who sought to end a pregnancy without her husband's consent, a stark demonstration of how the state's concept of justice was weaponized to enforce reproductive loyalty to the family line. This absolute demand for fidelity extended beyond the home to the temple, the other pillar of Assyrian power. A woman caught stealing from a sacred place faced execution, her act of theft seen not as a simple crime, but as a profound betrayal of the gods and the king. This fusion of religious, state, and domestic authority created an inescapable web of control. When we hear modern debates over reproductive rights and bodily autonomy, how much of that ancient struggle for control over women's lives still echoes in our courtrooms and legislatures? The Assyrian system represents one of history's most extreme attempts to legislate loyalty through fear, a stark contrast to the legal tradition that was simultaneously taking shape in a land of rolling hills and olive groves, where justice would be sought not in the wrath of a king, but in the reasoned words of a lawgiver. Amid the stark, windswept peaks of Mount Sinai, a new legal framework was forged, one that would bind a people to their God and to each other. The Covenant Code, detailed in the biblical books of Exodus, presents a profound fusion of divine commandment and earthly jurisprudence. It was here that Moses was said to have received these laws directly from Yahweh, providing a religious and legal constitution for a nomadic society on the cusp of nationhood. This code redefined justice not merely as a civic duty, but as a direct expression of loyalty to a single, sovereign deity. Biblical scholar John Barton emphasizes that this represents a pivotal moment in the history of law, the birth of a system where ethical obligations are rooted in the character of God himself. The laws meticulously outlined in Exodus chapters 21 through 23 cover a vast terrain, from slavery and assault to property rights and religious festivals. Yet woven throughout is a revolutionary thread of compassion for the most vulnerable. The code commands, "You shall not wrong a stranger or oppress him, for you were strangers in the land of Egypt. You shall not afflict any widow or orphan." This was a radical mandate, elevating the protection of the marginalized from a charitable act to a core tenet of divine justice. Even within the accepted hierarchies of the time, the code introduced startling principles of rest and dignity. It required that slaves, both Hebrew and foreign, be granted a day of rest on the Sabbath, a law that implicitly recognized their humanity and placed a limit on their exploitation. This concept of legislated compassion extended to the economic sphere. Farmers were instructed not to strip their fields and vineyards completely bare. They were to leave the fallen fruit and the edges of their harvest for the poor and the stranger. This statute actively promoted a loyalty to community welfare that superseded absolute property rights, building a social safety net directly into the fabric of agricultural law. How do our modern humanitarian efforts, from international aid for refugees to local food bank initiatives, reflect this ancient mandate to consciously provide for the marginalized? The Covenant Code's powerful fusion of faith and fairness created a legacy where justice is measured by how a society treats its least powerful members, a standard that would go on to challenge empires and shape the conscience of the world. Yet the quest for a stable legal order could take a terrifying turn. In 7th century BC Athens, a lawgiver named Draco was tasked with quelling the city's violent social strife, and his solution was to inscribe a new constitution of such unyielding severity that his name would forever be synonymous with merciless justice. The Athenian aristocracy, locked in a power struggle, demanded written laws to curb arbitrary rulings and force loyalty toward the state itself, rather than toward rival noble families. Draco's code answered this demand with a single, brutal standard for nearly every crime: the penalty of death. Theft of a cabbage, idleness, even minor offenses could lead to execution. The ancient historian Plutarch would later write that these laws seemed to be written not in ink but in blood. This was justice engineered for absolute deterrence, an attempt to use pure terror to forge civic order. The laws governing debt were especially revealing of this skewed loyalty. A defaulting debtor, often a poor farmer, could be sold into slavery by his creditor, a punishment that protected the property of the wealthy while utterly destroying the life of the vulnerable. It forces us to reflect: in what ways do modern legal systems still disproportionately punish the poor, whether through excessive fines for minor violations or bail systems that incarcerate people simply for their poverty? Draco's constitution, for all its harshness, established a critical precedent that the law should be a public, written text, but its extreme nature soon proved untenable. The very brutality meant to create stability would soon ignite a demand for a more compassionate and balanced form of justice, one that would transform Athens into the cradle of democracy. Athens was on the brink of collapse. The draconian terror meant to enforce loyalty had instead pushed the city toward civil war, with a chasm of debt and despair separating the wealthy aristocracy from the impoverished masses. Farmers were being sold into slavery for debts they could never repay, their bodies treated as collateral. Into this crisis stepped Solon, a statesman and poet appointed with supreme authority in the early 6th century BC. He was tasked not with tightening the screws of oppression, but with the monumental challenge of healing a fractured society. His solution was a series of revolutionary reforms that would redefine Athenian justice and rebuild civic loyalty from the ground up. The centerpiece was the seisachtheia, the shaking off of burdens. With a single stroke, Solon cancelled all outstanding debts and freed every Athenian who had been enslaved because of them. This was not merely an economic policy, it was a profound act of social restoration. He literally brought citizens home, restoring their place and their voice within the polis. The historian Aristotle, in his work on the Athenian Constitution, praised Solon for establishing a government that balanced power, preventing both the tyranny of the nobles and the chaos of mob rule. Solon's vision extended far beyond a one-time debt cancellation. He created new courts, the Heliaia, where any citizen, regardless of wealth or status, could serve as a juror and appeal the verdicts of aristocratic magistrates. This broke the noble family's monopoly on legal interpretation and made justice a public, participatory process. Even more radical was his introduction of the legal principle that any citizen could seek redress in court for a crime committed against another. This transformed justice from a private vendetta into a collective civic duty, fostering a powerful new loyalty to the law itself. How do modern debt relief programs designed to prevent economic collapse and social unrest compare to Solon's radical shaking off of burdens? His reforms created the foundational belief that the law should protect the many from the power of the few, a principle that would soon fuel the birth of democracy. Yet this Greek experiment in popular justice was not the only path emerging in the ancient world, as another civilization began to inscribe its own, deeply pragmatic vision of order onto bronze for all to see. While the Athenians were experimenting with democratic justice on the sun-drenched island of Crete, the city of Gortyn was carving its own legal legacy into a circular stone wall around 450 years before the Common Era. The Gortyn Code stands as a monumental text, one of the most complete and revealing examples of ancient Greek civil law ever discovered. Unlike the grand, God-given proclamations of Hammurabi or the constitutional reforms of Solon, this code was intensely practical, a meticulous blueprint for resolving the everyday disputes of a bustling community. Its thousands of lines, meticulously arranged in Boustrophedon style, winding like an ox plowing a field, covered everything from property disputes and inheritance to the intricate details of family life and slavery. The code's genius lay in its procedural focus, creating a standardized system of justice that built loyalty by making the law's application predictable and fair for all citizens. Legal expert Michael Gagarin has pointed to the code's surprisingly advanced stance on women's rights, particularly in matters of divorce and property. In a world where women were often treated as legal dependents, the Gortyn Code granted them clear agency. It stipulated that if a woman initiated a divorce, she was entitled to take her own property and half of the household's produce, provided the separation was her husband's fault. This was a radical acknowledgement of a woman's economic personhood, fostering her loyalty to a legal system that actively protected her interests. The code's intricate regulations extended deeply into the complex web of social status. It carefully defined the rights and obligations of individuals in mixed-status relationships, such as those between free citizens and slaves. For instance, the children of a free woman and a male slave were considered free, but if the situation was reversed with a free man and an enslaved woman, the children would inherit her status as slaves. These laws were not about equality, but about creating a clear, predictable social hierarchy that minimized conflict and reinforced communal norms. One of the most telling statutes involved the heiress or epikleros. If a man died with no male heirs, his daughter became the vessel for the family's property. The code required her to marry her father's nearest male relative, even if she was already married to someone else. This law brutally prioritized the loyalty to the family lineage and the preservation of its wealth above the personal desires of the woman herself, binding the entire kinship group together through legal obligation. It makes you wonder, in what ways do modern inheritance laws and trusts, designed to keep wealth within a family, echo this ancient, sometimes coercive, concept of familial duty? The Gortyn Code reveals a sophisticated civilization that understood justice as a detailed, procedural machine, one that balanced individual rights with the overwhelming demands of social and familial loyalty, a complexity that would soon be challenged by a very different kind of thinker, one who would ask not what the law said, but what justice itself truly was. The plebeians of Rome had reached their breaking point. For generations, the city's wealthy patrician class had held a monopoly on legal knowledge, interpreting unwritten traditions in ways that consistently favored their own interests. This struggle of the orders, a deep-seated conflict between the common people and the aristocracy, finally forced a dramatic change around 450 years before the Common Era. The plebeians demanded that the laws be written down and made public, so that justice would no longer be a secret weapon of the powerful. In response, a commission of 10 men, the decemvirs, was appointed to codify Rome's first comprehensive legal constitution, the Law of the 12 Tables. These bronze tablets, displayed publicly in the Roman Forum, became the bedrock of all Roman law, transforming justice from a private privilege into a public, accessible matter. The Roman historian Livy would later describe them as the fountainhead of all public and private law, the source from which the vast river of Roman jurisprudence would flow for centuries. The tables covered a breathtaking range of topics, from court procedures and property rights to the intimate details of family life and inheritance. Their very existence instilled a new form of loyalty to the state, guaranteeing every citizen, regardless of class, certain fundamental protections. One of the most significant was the right to a trial, a formal process that replaced arbitrary seizure and summary punishment. The laws also sought to curb the worst excesses of debt slavery, a constant threat to the plebeians. Table 3 outlined a strict procedure for debt repayment, allowing creditors to seize a defaulting debtor and even put him in chains. Yet it also set crucial limits, stating that if the debtor was held in bondage, he must be released after 60 days, and if multiple creditors demanded his labor, they were permitted to cut his body into pieces, though most historians believe this gruesome final provision was a stark warning rather than a common practice, meant to emphasize the seriousness of the debt. This brutal but regulated system represented a fragile balance of power, offering creditors a remedy while acknowledging the humanity of the debtor. The commitment to public justice was further cemented by a law requiring that any trial involving a citizen's life or liberty must be held before the greatest assembly, the comitia centuriata. This ensured that capital punishment was not a sentence handed down in a shadowy room, but a decision made by the community itself, fostering transparency and collective responsibility. How do the principles first carved onto those bronze tablets, like the right to face your accuser and the demand for public proceedings, continue to shape the courtrooms of today? The 12 tables did not create equality, but they did create a foundation of known rules, a pivotal step that would allow Roman law to evolve into an engine of empire, refined over centuries by the sharp, pragmatic minds of its jurists. The blood-soaked conquest of Kalinga left a deep and unexpected scar on the Emperor Ashoka. In the wake of a victory that claimed hundreds of thousands of lives, this Mauryan ruler of the 3rd century BC experienced a profound conversion, turning from the path of the sword to the teachings of the Buddha. From this personal transformation emerged a legal philosophy that would redefine justice for his entire empire, a system based not on punishment but on dharma, the universal moral law. Ashoka had his new constitution carved directly into the living rock of the Indian subcontinent, a series of edicts that demanded loyalty to ethical principles above all else. These were not laws in the traditional sense, but heartfelt instructions for building a compassionate society. He addressed his subjects with a stunning declaration of paternal care, writing, "All men are my children. As for my children, I desire that they may be provided with complete welfare and happiness in this world and in the other world." This was the foundation of his justice, a ruler's profound duty to ensure the well-being of every person under his care. The edicts translated this philosophy into tangible action, mandating the construction of hospitals for both people and animals, and planting shade trees and digging wells along trade routes to offer respite to weary travelers. He issued decrees that prohibited the wasteful slaughter of animals in royal kitchens and banned large-scale sacrificial rituals, framing non-violence as a core tenet of state policy. His rock edicts specifically instructed his officials, the Rajukas, to act with fairness and impartiality, to work for the welfare and happiness of the poor and the aged, and to ensure that judicial proceedings were free from harassment or undue imprisonment. How does Ashoka's ancient vision of a welfare state, where the government's primary role is to actively promote the happiness of its citizens, resonate with modern ideals of humanitarian governance and corporate social responsibility? His empire was held together not by fear, but by a shared commitment to compassion, a radical experiment in ethical rule that challenges our understanding of power even today. This profound shift toward a justice rooted in universal care invites us to journey further east, to a land where a very different, yet equally enduring, legal philosophy was being meticulously compiled. In the warring states of ancient China, a brutal philosophy of power was taking hold, one that would forge a fractured land into a single, terrifyingly efficient empire. The Qin dynasty, under its first emperor Qin Shi Huang, embraced legalism, a school of thought championed by the ruthless minister Shang Yong. This was not a justice of compassion or divine balance, but a cold, mechanical system designed for one purpose: absolute control. The Qin legal code became the engine of this state, a web of laws that enforced loyalty to the emperor through a simple calculus of reward and severe, unforgiving punishment. As sinologist Robin D. S. Yates explains, the Qin state operated like a machine where every citizen was a cog, and any malfunction was met with immediate, brutal correction. The code's most chilling innovation was the doctrine of collective responsibility. Families were grouped into units of 5 or 10 households, and every member was held legally liable for the crimes of the others. If one person committed treason, the entire group could face execution. This policy transformed neighbors into watchmen, and communities into prisons of mutual surveillance, where loyalty to the state was enforced by the fear of your own kin. The statutes themselves were meticulously detailed and shockingly severe. The theft of a single horse or the failure to report a crime could lead to mutilation, such as having a foot cut off, or to conscription into the massive, grueling labor projects that built the Great Wall. There was no room for mercy or judicial discretion. The law was a rigid, unfeeling standard applied to all. Yet, for all its brutality, the Qin legalist system was breathtakingly effective at standardization. It imposed uniform weights and measures, a single currency, and a consistent written script across all the conquered territories. This administrative uniformity was a form of justice in itself, creating a predictable, if merciless, framework for every transaction and communication. How do modern state surveillance systems, with their vast networks of digital monitoring and data collection, compare to the Qin's method of holding entire communities accountable for individual actions? While our tools have evolved from neighborhood watch groups to algorithmic profiling, the underlying goal of engineering social conformity through pervasive oversight remains a powerful and unsettling parallel. The Qin dynasty collapsed in flames after only 15 years, but its legalist skeleton would be clothed in the softer robes of Confucian virtue by the Han dynasty that followed, creating a hybrid system of power that would endure for 2 millennia. Yet the Qin's reign of terror proved too brittle to last. Its collapse opened the door for the Han dynasty, which ruled China for 4 centuries beginning in 206 BC, and they faced a monumental task: how to govern an empire without breaking its spirit. Their brilliant solution was a profound legal synthesis, weaving the harsh, necessary framework of legalism with the compassionate, human-centered ethics of Confucianism. This fusion created a system where justice was redefined not as mere control, but as moral cultivation. The Han reforms were guided by a central Confucian tenet from the Analects, that a ruler who governs by virtue is like the North Star, which remains in its place while all the other stars pay homage to it. This shifted the entire goal of the law, from compelling obedience through fear to inspiring loyalty through virtuous example. Officials were now expected to be paragons of ethical behavior, their primary duty to educate and uplift the people, not just to punish them. This philosophical shift led to concrete, humane changes in the legal code. The Han emperors systematically reduced the Qin's brutal mutilation punishments, replacing the cutting off of feet or noses with less severe penalties like beatings with a stick or hard labor. They introduced formal appeals processes, allowing convictions to be reviewed by higher authorities, a crucial check on local corruption and judicial error. Justice became more deliberative, seeking to understand context and intent rather than just mechanically applying a brutal statute. The law also became a powerful tool to enforce the Confucian virtue of filial piety, the bedrock of social order. Statutes were enacted that legally required adult children to provide material support for their aged parents. A son who neglected this sacred duty could face serious penalties, including forced labor. This legally bound the most intimate family loyalty to the obligation of the state, making the stable, respectful family unit the foundation of a stable empire. How does this ancient enforcement of filial duty compare to modern laws in many countries that legally mandate children to provide for elderly parents, or to our contemporary restorative justice programs that seek to repair harm through dialogue and moral accountability rather than pure punishment? The Han Dynasty's great achievement was to demonstrate that law could be more than a weapon. It could be a teacher guiding society toward a more harmonious and ethical existence, a vision of justice that would deeply influence all of East Asia for 2,000 years. Across the Indian subcontinent, a different kind of order was being meticulously defined, one written not on rock but on palm leaves. The laws of Manyu, composed between 200 years before the Common Era and 200 years after, presented a complete vision of society where justice was synonymous with Dharma, the cosmic law governing all existence. This was not a code handed down by a single king, but a sacred treatise on duty, a divine blueprint for how every person should live. Its central guiding principle was one of absolute loyalty to one's prescribed role. The text itself declares, "It is better to discharge one's own duty imperfectly than to perform another's duty perfectly." This idea wove social stability and cosmic order into a single, unbreakable thread, where a person's virtue was measured by their fidelity to their station in life, a system of 4 main classes or varnas, from priests and warriors to merchants and laborers. Justice under Manyu was therefore not blind but intensely discerning, calibrated to an individual's social and spiritual status. The prescribed punishment for the same crime varied dramatically. A priest who stole gold would be fined, while a laborer committing the same theft could be put to death. This was a legal framework designed to maintain hierarchy, viewing the preservation of the social structure as the highest form of justice itself. The laws reached deep into the family, strictly regulating marriage and inheritance to ensure purity of lineage and loyalty to the patriarchal household. A woman's life was legally defined by male guardianship, first by her father, then her husband, and finally her sons. Her primary duty was unwavering loyalty to her husband, with the text stating that a wife must never do anything displeasing to her husband who took her hand in marriage. This legal subordination extended to property, where a woman's right to inheritance was severely limited, ensuring that wealth remained under the control of male lineage. The king's duty was to be the living embodiment of this system, the protector of the social order. He was instructed to punish wrongdoers, but his justice had to be proportional to caste, punishing a priest with a gentle word and a laborer with violent force. This intricate legal philosophy, which bound law, religion, and social duty into one, forces a difficult reflection. How do the historical echoes of such a rigid, role-based system inform our modern debates about social equality, affirmative action, and the ongoing struggle to balance individual potential against the weight of inherited social identity? The laws of Manyu created a world where loyalty to your place was the ultimate virtue, a concept that would be challenged millennia later by a very different voice proclaiming that all men are created equal. The Roman Empire was fracturing, its western provinces slipping into chaos, when Emperor Theodosius II ordered a monumental act of preservation. In the early 5th century of the Common Era, facing barbarian incursions and internal division, his court in Constantinople compiled every general law issued since the reign of Constantine into a single, authoritative work, the Theodosian Code. This was not a new constitution, but a massive act of legal consolidation, a 16-book collection designed to standardize Roman law across a divided empire and enforce a desperate loyalty to a Christian emperor. As historian John F. Matthews has observed, the code was a deliberate attempt to impose unity and orthodoxy through the force of law, creating a bedrock of tradition even as the political ground crumbled. Its statutes reached into every corner of public life, from tax collection and municipal duties to the very definition of religious truth. The code criminalized heresy and paganism with severe penalties, transforming religious conformity from a personal virtue into a legal obligation to the state. Justice was now inextricably linked to theological correctness. One of its most transformative innovations was granting bishops significant judicial powers, allowing them to preside over certain civil cases. This created a profound blurring of lines between church and state, where a holy man could also serve as a magistrate, interpreting disputes through a lens of faith. The code enforced ideological purity with tangible force, as seen in decrees against apostasy. Any person who abandoned Christianity to return to pagan rites faced the loss of their property and legal standing, a punishment that used economic and social ruin to ensure loyalty to the state religion. This fusion of spiritual and temporal authority raises a profound question for our own time. In an era where the principle of separating church and state is a cornerstone of many legal systems, how do we navigate contemporary debates where religious belief and civil law intersect, such as in matters of conscience or education? The Theodosian Code represents a pivotal pivot from classical legal thought, where law became a tool for enforcing orthodoxy, a legacy that would be carried forward into the medieval world and shape the next great project of legal codification. A king's conversion to Christianity demanded a new legal foundation for his people. When the Frankish king Clovis I embraced the new faith around 500 years into the Common Era, he ordered the creation of the Salic Law, a detailed Germanic code that sought to tame the violent customs of his warrior society. This legal text, known as Lex Salica, redefined justice not as a cycle of vengeance, but as a meticulous calculus of compensation and personal honor. At its core was the concept of wergild, the man price, a fixed monetary value placed on every free person. A homicide was no longer an automatic death sentence for the killer, but a debt that could be paid to the victim's family. The law stated clearly that if any person should kill a free Frank, he must pay 200 solidi. This was a staggering sum, meant to be a serious deterrent, yet it offered a path to resolution that avoided an endless, destabilizing blood feud. The entire system was built on this principle of regulated payment, fostering a fragile loyalty to the king's peace over the clan's vendetta. Medieval historian Patrick Geary has emphasized how this monetization of injury transformed justice into a negotiable value, channeling raw vengeance into a structured economic transaction that preserved social order. The Salic Law was astonishingly specific, detailing payments for a vast catalogue of offenses. The loss of an eye, an ear, or a thumb each had its own price. Stealing a pig was fined at a different rate than stealing a cow or a hive of bees. Every injury, from a broken bone to a severed finger, was assessed and valued, creating a predictable framework for resolving conflict. This intricate pricing of harm reveals a society deeply concerned with hierarchy. A free Frank's wergild was set at 200 solidi, but a Roman living under Frankish rule was valued at only 100, a stark legal declaration of ethnic stratification. The law's most far-reaching clause, however, had nothing to do with violence but with land and lineage. It explicitly barred women from inheriting ancestral land, a provision that would echo for centuries. By legally excluding daughters from the family's primary source of wealth and power, the Salic Law cemented a patrilineal system of dynastic loyalty, ensuring that land and the warriors it supported remained under male control. This single rule would later be invoked to justify excluding women from royal thrones, profoundly shaping the political map of Europe. When we see a modern court award monetary damages for a wrongful death or a debilitating injury, how are we participating in a system that, at its heart, still calculates the incalculable value of a human life? The Frankish solution to violence was to put a price on it, a pragmatic compromise that traded blood for silver and built the foundations of feudal law. Imperial China entered its golden age under the Tang Dynasty, a period of breathtaking cultural and administrative sophistication that produced one of history's most influential legal documents. The Tang Code, finalized in the 7th century, represented the ultimate synthesis of Confucian morality and legalist precision, creating a system where justice was meant to be both a deterrent and a teacher. This comprehensive administrative law demanded a dual loyalty, to the emperor as the head of state and to the family as the foundation of society, binding the personal to the political in a seamless ethical web. The code meticulously categorized offenses and prescribed penalties with a nuanced consideration of intent and circumstance, striving for a proportional fairness that earlier legalist systems often lacked. Legal commentaries from the era, such as the official annotations, explicitly stated that the very purpose of publishing the laws was to educate the people, to warn them against wrongdoing and guide them toward virtuous behavior, thus preventing crime before it could occur. At the heart of this system were the 10 abominations, a list of unforgivable crimes like treason, rebellion, and gross disrespect to parents, which were seen as direct attacks on the cosmic and social order and warranted the most severe punishments, including death for the entire family of the traitor. Yet this harsh framework was balanced by remarkable compassion in other areas. The code mandated lighter sentences for offenders who showed genuine remorse or who had elderly parents or young children dependent on them, recognizing that excessive punishment could create further victims and destabilize the very family loyalties it sought to protect. One statute even reduced the penalty for a thief who voluntarily returned stolen goods, rewarding contrition and the restoration of harmony. How does the Tang Code's foundational belief in law as a tool for moral education compare to modern criminal justice approaches that incorporate rehabilitation programs, restorative justice circles, and educational opportunities for inmates? The legacy of this pinnacle of Chinese jurisprudence is a powerful reminder that the most enduring legal systems are those that seek not merely to punish, but to cultivate a virtuous society, a quest for balanced justice that continues to challenge and inspire us today. Centuries after Theodosius, the Byzantine Empire stood as a shimmering fortress of faith and law. Under the ambitious Emperor Basil I in the 9th century, a new legal monument rose, designed to refine and reclaim the legacy of Rome. The Basilica was a monumental effort to streamline the vast, often contradictory, texts of Justinian's Corpus Juris Civilis, translating them from Latin into Greek, the living language of the empire. This was more than a simple translation. It was a profound Hellenization of Roman law, creating a unified and accessible system for the Eastern Roman Empire. Legal historian Bernard Stolt describes the Basilica as the definitive law book of the Byzantine state, a comprehensive code that seamlessly integrated classical Roman jurisprudence with the moral framework of Orthodox Christianity. Justice was redefined through a theological lens where loyalty to the emperor was inseparable from loyalty to God and his church on earth. The code's statutes regulated every aspect of life, from complex maritime trade agreements to the intimate bonds of family, all under the umbrella of divine authority. Marriage and divorce, for instance, were no longer purely civil contracts but sacramental unions governed by church doctrine. The laws strictly limited the grounds for divorce, reflecting the orthodox view of marriage as a permanent spiritual covenant, a legal bulwark designed to maintain the family as the cornerstone of a stable Christian society. This fusion of spiritual and temporal power was absolute at the highest levels of state. A key provision required imperial approval for all high-level appointments in both the military and the clergy, ensuring that access to power was granted only to those whose loyalty to the crown and its faith was beyond question. This system prompts a challenging reflection for our own era. In a world where many constitutions are built on a strict separation of religious and state authority, how do we navigate the persistent influence of religious doctrine on modern laws governing life, death, and family? The Basilica's grand synthesis created a durable legal blueprint that would shape the development of law across Eastern Europe and Russia for centuries, preserving the bones of Roman order within the body of a medieval theocracy. From the theocratic courts of Byzantium, a new revelation emerged from the sands of Arabia that would forever alter the landscape of law. In the 7th century, the divine revelations of the Quran to Prophet Muhammad established Sharia, a comprehensive path to righteousness that redefined justice as an act of ultimate loyalty to God or Allah. This was not merely a set of rules, but a complete way of life, a divine legal framework governing everything from daily prayers and personal morality to complex commercial transactions and criminal punishments. At its core, Sharia pulsed with a profound emphasis on mercy, equity, and the welfare of the community. The Quran commands believers with unwavering clarity, "O you who have believed, be persistently standing firm in justice, witnesses for Allah, even if it be against yourselves or parents and relatives." This established a divine mandate for fairness that superseded even the strongest tribal and familial bonds, forging a new loyalty to a universal truth. Recognizing the need to apply these eternal principles to an ever-changing world, early Islamic jurists developed distinct schools of thought, such as the Hanafi and Maliki, which balanced the fixed, revealed texts with reasoned interpretation and local custom. This intellectual tradition ensured that divine justice remained living and adaptable, not a rigid, frozen code. In criminal law, this balance is vividly seen in the concept of qisas, or retribution for crimes like homicide. While the principle of a life for a life was permitted, the system overwhelmingly encouraged forgiveness and compensation, or diya, to the victim's family. This channeled the ancient human impulse for vengeance into a structured resolution that healed societal rifts rather than perpetuating them. Perhaps the most revolutionary legal obligation was zakat, the compulsory almsgiving. By mandating that a portion of wealth be redistributed to the poor and needy, Sharia built economic justice directly into its spiritual foundation, fostering a powerful, tangible loyalty within the Muslim community, or Ummah. How do these ancient principles of socially responsible finance and ethical commerce continue to shape modern Islamic banking, which prohibits exploitative interest and promotes risk-sharing investments? The emergence of Sharia was a transformative fusion of spirituality and jurisprudence, creating a legal tradition where every judgment was also an act of worship, and justice was the visible proof of faith. The mist hung low over the water meadows of Runnymede in 1215. There, a group of powerful English barons confronted a deeply unpopular king, John, and forced him to affix his royal seal to a document that would become a cornerstone of liberty. The Magna Carta, the Great Charter, was born not from idealism, but from a brutal feudal dispute over taxes and power. Yet its principles shattered the ancient doctrine of absolute royal authority, redefining justice by proclaiming that the king himself was not above the law. For the first time in English history, a written document demanded loyalty to a higher legal standard, one that even the monarch was bound to obey. The Charter's famous Clause 39 declared with revolutionary clarity, "No free man shall be seized or imprisoned, or stripped of his rights or possessions, or outlawed or exiled, or deprived of his standing in any other way, nor will we proceed with force against him, or send others to do so, except by the lawful judgment of his equals or by the law of the land." This was the birth of due process, a legal shield against arbitrary imprisonment and the whim of a tyrant. It established that a person could only be judged by a jury of their peers, preventing the king from acting as the prosecutor, judge, and executioner in his own case. This single clause tore a hole in the fabric of absolute power, creating a space where the rights of the individual could begin to grow. The barons who forced King John's hand were not fighting for universal democracy. They were protecting their own feudal privileges and property from a capricious crown. But in doing so, they established a precedent that would echo far beyond the interests of the nobility, laying the groundwork for constitutional government itself. The Charter's insistence that the king's power had limits, that his actions could be challenged by a council of his subjects, planted the seed for parliaments and congresses. How do the democratic ideals enshrined in this 800-year-old parchment continue to inspire modern human rights declarations and the very structure of our governments? The Magna Carta represents a pivotal shift from loyalty to a person, the king, toward loyalty to a principle, the rule of law, a concept that would travel across oceans and centuries to shape the modern world's understanding of justice and accountability. High in the Andes, the Inca Empire wove a social fabric so strong that its threads still hold lessons for us today. This vast territory, stretching thousands of miles along the South American coast before the 16th century, was governed without money, without wheels, and without a written language. Its stability relied on a revolutionary legal principle called the mitta, a mandatory labor tax that transformed civic duty into the very currency of justice and loyalty. Every able-bodied subject was required to contribute a portion of their time to state projects, a rotational service that built the empire's magnificent roads, terraced its mountainsides for agriculture, and maintained its storehouses. In return, the state, personified by the god King Sapa Inca, provided security, organized the distribution of food and goods, and hosted communal feasts. This was not slavery, but a reciprocal obligation, a system designed to ensure that no one starved while others hoarded wealth. Anthropologists like Terence N. Daltroy have highlighted how the mitta fostered a powerful collective identity, binding diverse communities to the crown through shared effort and mutual benefit. The system was meticulously administered by local officials who recorded labor obligations on knotted strings called kippas, ensuring a fair rotation that prevented any single community from being overburdened. Laws were strictly enforced to prevent exploitation, with corrupt administrators facing severe punishment for mistreating workers or shirking their own duties. The breathtaking citadel of Machu Picchu itself stands as a monument to the mitta's power. Its precisely fitted stone walls and cascading agricultural terraces were not built by slaves, but by citizens fulfilling their rotational service. their labor simultaneously creating an architectural marvel and reinforcing their loyalty to the imperial state. This intricate balance of duty and care invites a direct comparison to our own time. How does the modern requirement for jury duty, or the concept of mandatory military service in some nations, reflect this ancient idea that citizenship carries an inherent responsibility to contribute to the public good? The Inca Mitta system demonstrates that justice can be woven from the threads of communal effort, creating a society where loyalty was earned not through fear, but through shared labor and guaranteed sustenance. These 22 foundational laws reveal a deep and persistent pattern in our human journey. Across continents and centuries, from the river valleys of Mesopotamia to the mountain citadels of the Andes, the evolution of justice followed a shared trajectory. It began with the monumental shift from unwritten custom to public, written text, when King Ur-Nammu carved his code in stone, and when the Roman 12 tables were displayed in the Forum. They transformed justice from a secret privilege of the powerful into a known standard for all. This act of writing down the law was a revolution in transparency, reducing the arbitrary whims of rulers and fostering a new, more resilient loyalty to the system itself. Legal historian Michael Gagarin notes that the very act of publication created a permanent reference point, a shared truth that citizens could invoke against corruption. This was the first step in building a society governed by rules, not by men. Another powerful pattern emerges in the constant tension between brutality and compassion. The same code of Hammurabi that demanded a life for a life also contained provisions to protect debtors from ruin. Emperor Ashoka's rock edicts, preaching non-violence and care for the sick, existed alongside the Middle Assyrian laws that treated women as property. This duality was not hypocrisy, it was a pragmatic balancing act. Harsh penalties for treason or theft were designed to deter chaos and protect the state, while compassionate measures for the poor, the widow, and the debtor were essential for maintaining social cohesion and preventing revolt. This ancient seesaw between the stick and the carrot reflects a timeless understanding that a legal system cannot survive on fear alone. It must also cultivate consent and care. Religion and philosophy provided the moral compass for these legal systems, transforming raw power into righteous order. The Covenant Code framed its laws as divine commandments, linking civic duty to spiritual consequence. The laws of Manu rooted justice in the cosmic principle of Dharma, while Confucian ethics taught the Han Dynasty that law should be a tool for moral cultivation. This infusion of higher purpose gave legal codes their enduring authority, persuading people that obeying the king was not just a practical necessity, but a sacred duty or a path to virtuous living. It answered the profound human need for meaning, connecting everyday justice to a grander cosmic plan. Perhaps the most practical function of these ancient codes was their role as engines of empire. The Tang Code standardized administration across a vast and diverse China. Roman law, from the 12 tables to the Theodosian Code, provided a common legal language that bound together countless cultures from Britain to Syria. The Inca Mitta system wove a tapestry of loyalty through shared labor. By imposing uniform standards of justice, measurement, and obligation, these legal frameworks dissolved local differences and created a new, overarching identity as a subject of the empire. This legal standardization was the glue that held ancient superpowers together. We see this same imperial logic in the recurring concern for economic justice, a thread that connects Solon's shaking off of burdens in Athens to the debt release laws in the Covenant Code. These were not random acts of charity, they were calculated interventions to prevent societal collapse. by periodically canceling debts and freeing those enslaved by them. Ancient rulers released the pressure valve of social unrest, restoring balance and reaffirming the loyalty of the desperate. This pattern asks us a direct question: how do our modern economic policies, from stimulus checks to bankruptcy protections, serve this same ancient purpose of maintaining stability through targeted relief? Stepping back to view this entire legal tapestry, what do these patterns ultimately reveal? They show us that our ancestors were not just creating rules, they were endlessly experimenting with the same fundamental problems. How do we balance power with mercy? How do we build loyalty in a diverse society? How do we translate our highest ideals of fairness into a working system of order? The answers they carved in stone and clay were imperfect, often brutal, and deeply rooted in their time, yet the questions they wrestled with are strikingly familiar. Our continued struggles for equity, for transparent governance, and for a justice that truly protects the vulnerable are all part of this same ancient conversation. The legacy of these 22 foundational laws is not a set of outdated commandments, but a living reminder that the quest for a just society is humanity's oldest and most enduring project. Our journey across 4,000 years of legal history reveals a profound truth: justice is humanity's most enduring creation, a project we have been building together since the first laws were carved in stone. From the calculated silver payments of Ur-Nammu to the defiant barons at Runnymede, each of these 22 foundational codes represents a crucial step in our collective struggle to impose order on chaos and to weave compassion into the fabric of power. These systems were never frozen in time. They evolved with every new cultural encounter, every philosophical insight, and every religious revelation, constantly recalibrating the balance between the authority of the state and the dignity of the person. At the heart of this evolution was the powerful engine of loyalty, a force that bound people to a ruler, a god, or a community, and in doing so, forged the very identities that would define empires and nations. The Roman orator Cicero once declared that the welfare of the people is the ultimate law, a sentiment that resonates through the ages, from Ashoka's paternal edicts to the Tang Code's educational purpose. This ancient wisdom challenges us to look at our own world. How do these historical foundations inform the legal debates we face today over digital privacy, corporate accountability, and universal human rights? I invite you to reflect on which of these ancient laws you find most compelling or surprisingly relevant to our modern dilemmas. Share your thoughts in the comments below. Your perspective is part of this ongoing conversation. Thank you for exploring these mysteries of history with me. If you enjoyed this deep dive into the origins of justice, subscribe for more journeys into the past, and together, let us continue to learn from those who came before us, building a future anchored in the hard-won wisdom of the ages.